So as we all know, the big political drama in America at the moment is President Trump's decision to replace the late Supreme Court Justice Ruth Bader Ginsburg, widely considered to be one of the most left-wing judges on the Supreme Court, with Amy Coney Barrett, widely considered to be one of America's most right-wing judges. This whole situation is seen as bringing a new level of intensity to the 2020 American presidential election, since controlling who winds up on the Supreme Court is now one of the biggest fights in American politics. But what is interesting about this whole obsession with the Supreme Court is that it is actually a relatively new thing. In fact, the way that we talk about the Supreme Court these days would have been considered fairly weird for most of American history. To explain why, let me first summon Mr. Beat, everyone's favorite YouTube American history teacher.
Hey JJ, thanks for letting me interrupt your award-winning video. My name is Mr. Beat, and I do teach American government, so I know a thing or two about the Supreme Court. Plus I have that Supreme Court Briefs series you can check out when you're done watching this video and stuff. The Supreme Court originally was not meant to be partisan. It was not meant to be something that voters thought about. It was supposed to be immune from politics and really didn't have that much power in the early days. The Constitution itself didn't even get around to talking about the Supreme Court until Article 3, and then when it did, it's just like, it doesn't even say that much. But then a few years later, after the Constitution is ratified, you get to a dude named John Marshall. John Marshall ends up being the most impactful Supreme Court justice in American history. Now, what's weird is that he's appointed by President John Adams, a Federalist who was very partisan, and he appointed Marshall for partisan reasons because he knew that the Democratic Republicans were taking over the executive branch, and he wanted to continue the influence of the Federalist Party because he knew he could rely on his boy, Little John. But the thing is, over his 34 years in the Supreme Court, John Marshall ended up not being that partisan. He did, though, dramatically expand the power of the Supreme Court, beginning with the most important Supreme Court case in American history, Marbury v. Madison. That was the case which established judicial review, which was the idea that the Supreme Court could determine whether or not something was constitutional in the first place. Despite all that, throughout most of the 1800s and the first half of the 1900s, the Supreme Court really doesn't have too much of an impact on most policies of the country. That starts to change in the 1950s. You got another Chief Justice by the name of Earl Warren. He is appointed by a Republican, Dwight Eisenhower, but he ends up being more of a left-leaning justice. And he's a Chief Justice who is very influential, but also considered by many to be more of an activist justice. It wasn't just him. Others in the Supreme Court in the 1950s and 1960s into the 1970s were considered activist justices who did lean more to the left, and they had a huge influence. Big decisions. But JJ, I know I was supposed to keep this short, so I've already broken that promise. Back to you.
Thank you, Mr. Beat. So as Mr. Beat just described, the American Supreme Court really didn't start exerting itself until the 1950s. Prior to that, it was mostly just seen as an institution that upheld the American status quo whenever it was questioned, be it on human rights or business or whatever. You could say it was a mostly conservative institution in the sense that it wasn't really a force for change in American life. So check out this little book I have here. The 34 Supreme Court cases that most affect your life. According to this, a full 30 of those cases occurred after the year 1950, with a full 28 occurring after 1960. So what changed in the 1950s and 60s? Well, lots of things, but obviously a large part of it had to do with the changing philosophy of American judges and lawyers in the post-war years. The 1950s and 60s saw the mainstreaming of what is now often described as a more interpretist or activist or just liberal understanding of a judge's role when it comes to not only upholding the law and constitution, but also honoring the larger purpose of the nation's constitution and laws. This interpretist liberal legal theory goes something like this. The American Constitution promises to protect fundamental human rights from the tyranny of the government, but its language is often vague. Therefore, a good judge should interpret the Constitution, and even some laws, as living documents whose protections and definitions can be expanded to strengthen liberty, equality, and democracy. During the 1950s, 60s, and 70s, this approach to interpreting the Constitution resulted in the court using the Marbury v. Madison principle, remember that, to issue a number of rulings that pushed American society in a more progressive direction. These included rulings that prevented teachers from praying or teaching creationism in public schools, rulings protecting obscene or treasonous speech, rulings expanding the rights of accused criminals through things like the Miranda warnings and government-appointed lawyers, and of course, rulings prohibiting governments and even private businesses from denying services to African Americans. Now, obviously, all of these rulings centered around very controversial issues. I mean, they're still controversial now, so you can only imagine how controversial they were a half century ago. And whenever things are controversial, they inevitably provoke backlash. In this case, the backlash took the form of a newly robust conservative or neoconservative movement that sought to stop American society from continuing to barrel down this irresponsible path of radical social reform as they saw it. As the famous conservative political commentator William F. Buckley Jr. put it in 1955, the mission of the conservative was to stand athwart history, yelling, "Stop." Now, the main story of this neoconservative movement was its success in taking over the Republican Party, but it had a whole legal dimension too. The big one was the creation of an alternative legal philosophy to challenge the dominance of the activist or liberal one. This new conservative legal philosophy went something like this. The Constitution promises to protect fundamental human rights from the tyranny of the government, but its language is often quite vague. Therefore, a good judge should enforce only the most restrained or traditional understandings of its protections and definitions in order to honor the document's original intent. If a law or the Constitution doesn't seem good enough, then it's the job of elected politicians to alter or update it. These days, we tend to call this philosophy originalism, or textualism, or constructivism. The most intense version of this involves doing actual historical research to try to understand the meaning of words in the laws or the Constitution as literally as possible, by tracking down old dictionaries or letters between politicians and this sort of thing. Now, as Mr. Beat said, the Constitution doesn't actually say all that much about the Supreme Court. Article 3 just says that there shall be a Supreme Court with judges who serve for life, and Article 2 says that the president shall appoint the judges with the advice and consent of the Senate. And back when the Supreme Court didn't really do much, appointing Supreme Court judges wasn't considered that much of a big deal. Presidential nominations often barely made the news, and the Senate often just rubber stamped them with a unanimous voice vote, which is the kind of thing they only do for their most uncontroversial business, like declaring Apple Pie Awareness Month or whatever. All that changed with Nixon, who was the first Republican president to attempt some sort of pushback against what he saw as the leftward drift of the Supreme Court. President Nixon said he would only appoint strict constitutional constructionists, but it wasn't so easy. Of the 6 judges he put forward for nomination, 2 were rejected by a Senate where liberals in both the Democrat and Republican parties held a majority. And of the 4 judges Nixon did get confirmed, one of them, William H. Rehnquist, had the closest Senate vote in 40 years. Nixon's difficulties getting conservatives appointed was a big deal because the Senate rejecting a president's pick for the Supreme Court had only happened 4 times in the last 100 years. And in these fights against the Nixon picks, the idea that these judges were too right-wing, particularly on civil rights, was always explicitly brought up as at least part of the justification for voting against them. Yet Nixon's troubles only made the conservative activists more determined. And in 1973, they got more determined still after the Supreme Court issued an extremely controversial ruling declaring abortion to be a constitutional right, known as Roe v. Wade. A lot of anti-abortion conservatives were super outraged about this, and to add insult to injury, 3 of the 4 Nixon judges actually supported the ruling. Only old man Rehnquist dissented. In 1982, 2 prominent conservative law professors Robert Bork of Yale and Antonin Scalia of the University of Chicago helped found a thing known as the Federalist Society that was determined to make the conservative philosophy of law more mainstream. As Amanda Hollis Brusky, the author of a book on the Federalist Society, puts it, the idea was to train, credential, and socialize a generation of alternative elites. Today, Politico says it's one of the most influential legal organizations in American history, with an intellectual reach and political clout that no other legal group can match. In 1980, Ronald Reagan was elected president of the United States, a very conservative Republican who was even more determined than Nixon to get good conservatives on the Supreme Court. In 1981, an old justice from the Eisenhower years retired, and President Reagan nominated Sandra Day O'Connor to replace him, a woman who had earlier been a Republican politician in Arizona. Though she was obviously politically on the right, the fact that she was also the first woman ever appointed to the Supreme Court helped mask any controversy, and she was unanimously approved by the Senate. But then, in 1986, Chief Justice Warren Burger resigned, and Reagan proposed that Old Man Rehnquist be promoted to Chief Justice to replace him, and it became this whole big controversial thing. Rehnquist was still seen as this right-wing Nixon guy, and though his promotion was ultimately approved, it was by the closest Senate vote for any Supreme Court judge up until that point. At the same time Rehnquist was promoted, Reagan also appointed Antonin Scalia, the Federalist Society guy, to the Supreme Court as well. In part because there was so much focus on Rehnquist, Scalia's appointment wasn't considered that big of a deal, and he was voted in unanimously. Then, in 1987, some really big drama occurred. Reagan's Republicans lost control of the Senate in the 1986 midterms, and shortly after the new Senate was inaugurated, President Reagan appointed the other Federalist Society guy, Robert Bork, who had since become an appeals court judge, as his next Supreme Court pick, following the retirement of one of the old Nixon guys. What followed was one of the most controversial episodes in the history of the Supreme Court. As a professor, Robert Bork had been a very vocal and public commentator on legal affairs, always from a very right-wing perspective. So he had basically argued against every major social reform that the Supreme Court had instigated over the last few decades, usually on the grounds that under a properly originalist reading of the Constitution, the court had no right to do half of the things it did. Democrats really seized on this opportunity to argue that Bork was a radical with views way outside of the mainstream, similar to what they had said about Rehnquist. But because Bork had explicitly written so much about his actual views, he was also a much easier figure to demonize. It is also important to note that 1987 was also the first year that television cameras were allowed in the US Senate, and this is often blamed for allowing senators to make an unprecedented spectacle out of things like Supreme Court nomination hearings, just because they knew that the public would see them. The classic example of this from the Bork hearings was this infamous speech by Democrat Senator Ted Kennedy, which a lot of Republicans said was incredibly unfair.
Robert Bork's America is a land in which women would be forced into back alley abortions, blacks would sit at segregated lunch counters, rogue police could break down citizens' doors in midnight raids, and school children could not be taught about evolution. Writers and artists would be censured at the whim of government.
Anyway, in the end, Bork was voted down, and in his place, Reagan nominated Anthony Kennedy, a more moderate conservative judge from California. In 1989, Reagan was replaced as president by fellow Republican George H.W. Bush. In 1990, another Eisenhower-era justice retired, and Bush nominated an obscure judge from New Hampshire named David Souter to replace him. Everyone assumed that Souter was some sort of conservative, but he was so obscure, no one could find much reason to vote against him, and he got in easily. He actually wound up being a liberal. Oops!
Oh, not Souter! Oh, no!
The same thing actually happened earlier with this guy, John Paul Stevens, who was appointed by President Gerald Ford during the 45 minutes he was in charge. Despite also being appointed by a Republican, Stevens went liberal too. In 1991, Justice Thurgood Marshall retired, who President Lyndon Johnson had appointed as the first ever black justice on the Supreme Court. Bush proposed he be replaced by another black judge called Clarence Thomas, who had worked for the Reagan administration. Thomas was known to be an arch-conservative like Bork, But what wound up almost sinking his nomination were allegations of chronic sexual harassment from a former coworker of his named Anita Hill. Much like the Bork hearings, this became this huge TV spectacle. Many conservatives said that Anita Hill was obviously lying and that this was just some lame effort by the Democrats to prevent another conservative from getting on the court. Thomas himself believed this and gave a sensationalistic speech that rivaled Ted Kennedy's.
As a black American, as far as I'm concerned, it is a high-tech lynching for uppity blacks who in any way deign to think for themselves.
Thomas was eventually confirmed in a very narrow 52-48 vote in a Democrat-controlled Senate. What's important about that vote is that it marked the last time that a Senate controlled by a different party than the president would approve one of his Supreme Court picks. In the 1990s, Democrat President Bill Clinton appointed 2 liberal judges to replace 2 retiring picks of Nixon and JFK, Stephen Breyer and the notorious Ruth Bader Ginsburg. Both were approved nearly unanimously by a Democrat-controlled Senate. Although for it to be nearly unanimous, many Republicans had to vote in favor as well, including some Republicans that are still in the Senate to this day. But in any case, that was also the very last time that any Supreme Court judge would get bipartisan approval. Republican George W. Bush became president in 2001, and he got to make 2 appointments as well. John Roberts Jr. to replace the recently deceased Chief Justice Rehnquist, and Samuel Alito to replace the retired Sandra Day O'Connor. And Democrats put up a big fight against both of them, which was kind of unusual because neither of them had any major scandals or controversies. However, by this time, both Republicans and Democrats were starting to get way more nervous and defensive about the balance of power on the court. The Republican goal of getting explicitly conservative judges on the Supreme Court had proven quite successful, and worried Democrats were starting to become a lot more open about just wanting to keep them out. It was becoming increasingly mainstream in liberal circles to just condemn conservative legal philosophy as basically intellectually and morally invalid. Accordingly, when President Obama came to power, Republicans embraced a similar disposition of knee-jerk opposition to all of his judicial picks, opposing Elena Kagan and Sonia Sotomayor for no real reason other than that they were liberals. But the Democrats had the majority in the Senate, so they got in anyway, albeit by margins that would have been considered hugely controversial in previous decades. And then, of course, things reached a peak in 2016 when, following the death of Justice Scalia, a now Republican-controlled Senate simply refused to even hold a vote on President Obama's 3rd nominee, Merrick Garland. This was basically the final nail in the idea that an opposite party Senate will even give a fair shake to a judge whose politics they disagree with. It's the same thing that's playing out right now with Amy Coney Barrett, who we just assume all Democrats will vote against because of how conservative she is, as opposed to some scandal or whatever. It's just like how Senate Democrats earlier voted overwhelmingly against President Trump's previous 2 picks, Neil Gorsuch and Brett Kavanaugh. I know the Kavanaugh thing was theoretically about a sex abuse scandal, but I think it's a bit naive to think that Democrats wouldn't have been opposed regardless. The Supreme Court of the United States has risen from fairly modest beginnings to become an extremely powerful institution in the American government, a small council of members for life who can invalidate laws they don't like or decree new laws that all Americans have to obey. From healthcare policy to presidential powers to LGBT rights to, of course, abortion, there's not much the Supreme Court doesn't have its hands in these days. This being the case, it is hardly irrational that America's political parties and the ideological movements they represent would come to see controlling this body as the ultimate prize in American politics, or even the main point of American politics. Republicans are feeling pretty pleased at the moment that their majority on the Supreme Court is looking so strong, but who knows how long it'll last. Democrats could theoretically make the court bigger someday. Judges can die unexpectedly, or they could just pull a suitor and change their opinions. So who knows? My parting question to you is just whether you think this current system is good or not, and if not, what are some obvious reforms you think should be made? Let me know in the comments, and I will see you all next week.